Hey all, Professor Tracy back with another lecture, this one on the statute of frauds. So the statute of frauds typically arises as a defense to formation of a contract. So let's jump to it. So the thing to understand is that the statute of frauds as just a basic rule requires that certain categories of contracts be in writing in order to be valid. But you don't want to lose sight of the fact that oral contracts are generally okay. But the statute of frauds says certain contracts need to be in writing. And one of the questions that should be going through your mind is, well, why would that be? Why would we do that? Well, the statute of frauds serves both a cautionary function and an evidentiary function. When we say cautionary, what we mean by that is by requiring a contract to be in writing, it serves as a way to drive home the seriousness of what somebody is doing, as opposed to something that may be entered into lightly or glibly because it's oral. The idea is, well, you've got to slow down. It's been put into writing. You've got something to read, to review, and you're signing it. There's a heaviness and a seriousness to it that encourages someone to pause before they're entering into the agreement. But the second function of it, and really I would say the reason it's called the statute of frauds, is because it serves an evidentiary function, meaning that by requiring a contract to be evidenced by some sort of writing, we have a memorial or a record of that agreement, that it exists. Right? That this is a true thing. What the person is asserting is true, and we have a record of that because it's here in writing. And that serves to ward off concerns about fraud, that somebody's making something up, lying about the existence of a contract, but it also serves a function of preserving something that with the passage of time, memories grow old, things get lost, that if something is reduced to writing and we have a record of it, it's more likely that we're going to have an accurate picture of whether or not a contract existed, and if so, what are the terms of that agreement. So when we think about the statute of frauds, there is, in the big picture of it, there's a three-step analysis that we're going to engage in. One, we're going to ask, does this contract fall into one of the categories that's covered by the statute of frauds? And two, we're going to say, is there a writing? If it does, right? So we only get to the writing part if we first decide, yes, it does fall into one of the categories covered by the statute of frauds. If it does, then we've got to look and say, is there a sufficient writing that satisfies the statute of frauds? And if there's not a sufficient writing, we want to ask, well, is there an exception that applies? Is the statute of frauds satisfied through this exception? So those are the three steps we're going to look at. So starting with the first step of does this contract fall within one of the categories that is covered by the statute of frauds, that we want to look and say, well, what are they? What are they? So there are six of them, six categories. The first is marriage, and we'll define these more in just a second. So we have marriage, we have year, land, executor, guarantee, and the sale of goods for $500 or more. And we can say a couple things before we dive in and define each of these categories or give more detail. We can say a couple things, which is one, we have a very nice acronym, right? MYLEGS here is an easy way to remember these categories. It's stupid, but it's a helpful way to remember them. The other thing to know here is that these first five, MYLEG, these are the common law categories. The common law categories, if we have a contract that's for real estate or for services, it's governed by the common law. These are the five categories we need to be thinking about. Does the contract fall within one of those categories? That sixth category there is the UCC, right? If we have a contract for the sale of goods, then we've got to ask ourselves under Section 2201, We're asking, okay, is this a contract for the sale of goods for the price of $500 or more? Meaning, if it's exactly at $500, it does fall within the statute of frauds. So if it's for $500 or more, so it's only if it's less than $500 that it's not covered, right? Not covered. So let's look at each of these categories. So with marriage, it's important to differentiate what we mean and don't mean by this marriage category. So what we mean here is the promise of property made in exchange for a promise to marry, or the act of marrying. It doesn't cover what you might think of when you see the word marriage there, the actual covenant, marriage covenant, or the engagement promise. It doesn't mean that's not what's in view, right? What's in view is somebody promising something in exchange for a promise to marry. And so that a promise of some sort of property, whether that's coming from the other future spouse or coming from somebody else, but it's made in exchange for the promise to marry. Then with year, there's a lot of nuance to this, right? That what we're asking is the contract capable of being performed within a year from when it was formed, from the time of formation or the date of formation? Is it capable of being performed within a year? If it's not capable of being performed within a year, then it falls within the statute, right? That's why the description's given the way it is. But there's some nuance to that, right? Because if you start thinking about all the possibilities, you need to kind of back up and think, okay, well, how would it work in this circumstance or that? So let's look at some of those. If we're measuring a year, you want to think about it this way. If we're looking at a contract and the agreed period of time is more than 1 year, pretty easy, right? Like if it's a service contract that's for a year and a half, or if it's for a 36-month period of time, then that's easy because the contract itself, we can say, yeah, it is not capable of being completed within a year because it is a 3-year contract or what have you. That's easy, right? If it's an agreed upon time period that's more than a year, pretty easy to say, yes, it falls within the year category. It's not capable of being completed within a year from formation. Then the other way, though, to think about this is, let's say, for instance, that I, contrary to anybody's wishes, have a musical performance at the local the local theater here, and that performance is to take place in December of 2024, but it's only going to be a 45-minute performance. But if I'm entering into that contract today, but it's not going to take place till, let's say, December 1, 2024, then that performance is not going to occur then more than a year from the date of formation, right? It's going to occur substantially more than a year from now, right? So that is, even though the performance itself is only a 45-minute performance, and once you hear my musical performance, it'll probably last quite a bit shorter than that, but nonetheless, the idea hopefully makes sense that if the date of performance is over a year away, even if the performance itself is only going to be 45 minutes, it's still not capable of being performed within a year from the date of formation. So it still fall within the category. Then there's what I've said is some oddness to this year category, which is, what if there's a right of early termination? A right of early termination, meaning that somebody has the option to terminate the agreement before its completion. Does that mean we could say, well, it is capable of being performed within a year because the person could terminate it early, right? Terminate it before. So even if it was supposed to be a 3-year period, if the reality is it could be terminated before that, then there's this question of, well, does that mean it doesn't fall within the statute? No, a right of early termination doesn't change it. It's still going, if it's a 3-year contract, has a right of early termination, we don't care. That doesn't mean it's suddenly capable of being performed within a year. We don't change it. It still falls within the category. Then what about a task that you agree that somebody's going to do a particular job, but we don't lay out a time frame for that. And there, you just need to be careful, which is you want to look at it and say, is this capable, when we ask, is it capable of being done a year? If there's no time period given, then you want to be really generous with it. So for instance, let's say it's a contract where somebody is supposed to build a bridge across, say, some particular bay. And everybody in the room thinks, you know what, that's probably going to take 3 or 4 years for that job to get done. But nothing is said in the agreement when they're talking about the agreement. Is it capable of being done within a year? And the answer is yes. If we didn't spell out the time period and we didn't, give dates or when it's going to be completed, that kind of thing, then we assume that it can be done within a year, even if that doesn't make sense. So you want to think, well, could Superman do it within a year? And the answer is absolutely, right? Absolutely. So we assume that it is capable of being done within a year. So you want to look at it and go, is it capable? Even if it's not probable, because how probable is it that Superman's going to come over and try to build your bridge for you? Not very, right? But you want to look and say, if they didn't lay out a time frame, you want to view it as, then we are assuming it can be done within a year. So what about if there is an offer of employment for life? You say something like, well, we assume that you're going to live another 20, 30, 40 years. So if you give somebody a job for the rest of their life. But what courts say in that case is it is actually capable of being performed within a year, because they take the dim view that your life may not go for another year. So employment for life, contrary to what we've said about a right of early termination, employment for life is actually capable of being performed within a year, which may not be the way you would want it. You would by default think of it, but that's the way it's typically analyzed by courts. So what about land, the land category? So we've looked at marriage, we've looked at the year category. When we talk about land, what do we mean? We're talking about real estate, right? The transfer of an ownership interest. We're talking about, it could be a mortgage interest, it could be a lease. Keep in mind here, when we say lease falling within the land category, it has to be for over a year. And if we talk about an easement, as whether or not the transfer of an easement or the grant of an easement falls within the statute of frauds, it's got to be also be for over a year. So when we say land, there are a lot of different land transfers that would fall in there, but some of them you want to be very careful that they are for over a year. When we say executor here, it's not that every agreement that the executor of an estate makes must be reduced to writing. Excuse me. Rather, what we're saying is that if the executor is promising to pay in the obligations of the estate out of her own money, which if you think about it, would be a unique decision, right? There are reasons you might do that, but it's a unique decision. They're using their own money to pay an obligation of the estate of the person that is deceased, right? And saying, I'm going to use my funds to pay that obligation. That if that's what's going on, we want to make sure that's actually what the executor intended to do, that that's actually the case, that the beneficiaries of the estate aren't making it up, because it's awfully beneficial to them, right? That the money not come out of the estate. So we want to be sure that that was what was intended. So we required to be in writing. When we talk about a guarantee, this is what it sounds like. You want to think about somebody like co-signing a loan. If someone's going to buy a car and has their parents co-sign that loan so they can get it. And when we talk about a guarantee, what we're saying is it's a promise to answer for the debts of somebody else, right? When you co-sign a loan, you're saying if that person defaults, I am agreeing to answer for that debt. They are incurring the debt, but I am going to guarantee it. I will answer for that debt. if they don't pay, right? It's not a situation where they're the co-maker of a note or something like that, where they're jointly liable on the note. What we're saying is, I am agreeing to answer for this debt in the event that they themselves do not pay. And when we think about a guarantee, there's this main purpose exception, which says that when we're looking at this guarantee, this agreement, this promise to pay if the other person doesn't pay, we want to make sure that the person doing the guarantee, whom we call the guarantor, if the main purpose is to benefit them, right? Like if they are, for instance, let's say I'm going to have my house painted and I have a huge house, and that the purchaser of the paint, the painter, that would be a good label for them, correct, right? That the painter needs somebody to guarantee the payment of that he's buying all this paint on credit that's needed, and that he needs somebody to guarantee, and I sign as the guarantor of that promise to pay the debt that's owed for the paint. Well, in that case, the main purpose of that whole transaction and the purpose of the guarantee is to benefit me. Even though the person actually purchasing it is the painter, the purpose of the transaction, though, is to benefit me. And if that's the case, then it's not within the statute of frauds, right? Because we don't question why you did it. We know why you did it, because you had something, you stood to benefit from that exception, right? From that guarantee, excuse me. But in another case where it is not the purpose, the main purpose of the guarantee is not to benefit you, it is to benefit the other person so they can get a car or whatever it might be, then we want to be sure, well, did that really occur? Because it's awfully convenient for the other person to make that up. So what about this last category, which is the sale of goods for $500 or more? Then this is what we've said already. It is only our only UCC category, and it is still $500. Yes, there have been proposals to increase that amount. They have not. They've been withdrawn. They were never widely adopted. So states have not changed this, right? This is still the rule for 2201, the UCC Statute of Frauds. The sale of goods, $500 or more, falls within the statute. So that's the category part of our three-step analysis. Then we've got to look at the writing part. We need to have a writing. Well, what do we mean by that? When we say writing, that we're not, remember this, that, remember even bigger than this is we're only talking about writing and needing a writing if we first decided that the contract falls within one of those 6 categories. If it does, then we say, okay, that contract falls within the statute of frauds. And we're going to look next and say, is there a writing that satisfies the statute of frauds, or writings? And because it can be, we can piece together multiple writings, assuming it's clear that they're related. We can piece them together to satisfy the statute of frauds. But keep in mind that not every writing satisfies the statute of frauds, right? Just because a question or says there's a writing, or just because you find a writing when you're out in practice, you want to make sure, well, is it the kind of writing that satisfies the statute of fraud? But also, the statute of frauds can be satisfied without a writing. We can use one of the exceptions, so that we could still have compliance with the statute of frauds absent a sufficient writing. But we want to look and say, is there sufficient writing? And we need to distinguish between what the common law requires and what the Uniform Commercial Code requires. So the common law says the writing must have all material terms. All the material terms of the transaction, right? So we need to know it. Remember, common law, we have a contract for real estate or for services. So we need, what is it that are the essential terms, or material terms? We need to know who the parties are, what the price is. If there's a service, what's the service to be done? What's the scope of that service? We need to have evidence of those things, that it has all material terms. If it's property, does it identify the property? Do we know how much the property is? Is there some is there a timeline in there? Now, some of those things, just like when we talked about an offer needing certain indefinite terms, some of those things we can give a pass on, right? If the timeline is not critical to this transaction and we can say, well, we kind of know based on what a reasonable time is, that's good enough, then that's fine. So we're using the phrase all material terms rather than all essential is because it's a little bit context specific of, well, what is it that is material in this transaction? At the very least, it's going to be, if it's a services contract, we need to know what the services are and we need to know who we're talking about, who the service is provided, who it's provided to, and how much it's going to cost, those kinds of things. And so, and with real estate, you would need to know what piece of property are we talking about? Who's the buyer? Who's the seller? Do we know what the price is? Those kinds of things. So we also, and this is key, it must be signed by the defendant, right? Because keep in mind the way the statute of frauds arises. The plaintiff is running into court alleging that she has a contract with the defendant and that the terms of that contract were they were supposed to mow my lawn every Monday for the last 3 months and they didn't do it once, right? And I know that wouldn't fall in the statute of frauds. Let's say every other week for the next 3 years, that would fall within the year category, right? And if that's the allegation and the defendant's going to say, well, if there were such a contract, then it would fall within the statute of frauds because it's not capable of being performed within a year. It's a 3-year agreement. And therefore, then the plaintiff would need to come up with a writing. So keep in mind, you were like, well, why signed by the defendant? Because that's the person we're concerned about, right? That you're saying, I'm going to hold you to this agreement. I am suing you in court and holding you to this alleged agreement. So we want to know that, yes, the defendant did, in fact, enter into this agreement. So we want something that's authenticated by the defendant, the person you are asking the court to hold to the agreement. We want to say, did they agree to it? Yes or no? So they need to be signed by the defendant, right? That's the rule for the common law. So if we got Barb and Bob here, Bob says, all this land can be yours, Barb. 500,000. That's all I'm asking. Okay, you've got a deal. What? No writing? Ugh, get a grip, Tracy. We're getting there. It's going to be all right. So that's everything. We have the property description, the price, timeline for completing the sale, our names. You just need to sign it, and I think we're done. Alrighty, here's my signature. Now we should be good to go. So there, right, we've got what? All the material terms. Barb just ticked through them here, right? She said these are all the things that are there. And then Bob signs it. If he's our defendant, it doesn't really matter in this case because Barb signed it. We see her signature and we see Bob's, right? So they both signed it. So we can say, this is true, all material terms. And whoever, if there's a problem and one of them ends up getting sued, then it would have been signed by the defendant. Phew, close one. Will you please keep out of this? If you would have waited, everything would have been just fine without you jumping in at all. So what about under UCC? What about Article 2, 2201, the UCC Statute of Frauds? What does it say about a sufficient writing? Well, it tells us that there's 2 different possibilities for satisfying the statute of frauds under the Uniform Commercial Code. One is similar to, though not identical, similar to what the common law says, which is a writing signed by the defendant, which, keep in mind, is the only way to have a writing to satisfy the statute of frauds under the common law. But the UCC says, well, there's also this thing called a merchant's confirmatory memo. And so we're going to talk about, well, what are these? How do they work? So the first is a writing signed by the defendant, which again, yes, it's similar to the common law, but it's a little more liberal or gracious, because what it says is it has to indicate that a contract exists, be sufficient to indicate a contract exists, and it has to contain the quantity term. So the only thing that it requires by name, like by specification, is the quantity term, not all the material terms like the common law. Instead, it says you need the quantity term, and it has to be otherwise sufficient to indicate the existence of a contract, that the parties had some sort of agreement. But that could be quite limited, right? It could say something like, as you and I agreed, right? That this is, this confirms, here are the 6 table settings that you ordered from us. Then we would say, okay, we've got here a writing, right? Because it would indicate that there was an agreement, that they had a contract, and we now have a quantity term, right? There are 6 of the table settings, right? So when we say quantity term, we mean how many of whatever good it is. What's the quantity? And keep in mind, when you think back to the gap fillers, there's no gap filler for quantity, and so we need to know what the quantity is. Of course, we also need to know the identity of the good. Need to know, are we talking about jet airplanes? Are we talking about table settings? Are we talking about reams of paper or mugs? What is it we're talking about? We need to know that, right? But then, it, just like under the common law, it needs to be signed by the defendant, authenticated by the defendant, because that's the party that is being charged, being held to the agreement, and they're the one that's going to jump up and go, well, if such a contract existed, then this contract would fall within the statute. You need to come forward with some sort of writing that satisfies the statute of frauds or point to an exception that applies. So here we've got Bo and Barb. And here are the ewes I have for sale. With all that land you just bought from Bob, you'll have plenty of space for them to graze. Bo, these aren't even real. You're selling fake ewes. Sad. Really? Fake ewes? Fake news? Tracy, you have failed me for the last time. Ow, little Timmy Hurdy. Okay, let's get real, Bo. You're selling birds, I need birds, you understand? I got you, Herman. I tell you what, you can have all 4 birds for $600. Great, works for me. Can you draft up some paperwork, make things official? So here, what do we have, right? Bo goes, sure, this should do the job. So what does he have? All we need is, we need a writing, right? We're under the first possibility of a sufficient writing under the UCC. So we've got a contract for the sale of goods. Animals are goods, birds are goods, right? So we've got birds. And as we're looking at this, right, you want to say, well, what do we need, right? It has to be sufficient to indicate a contract exists. Well, this indicates that this is an invoice that's addressed to Herman, right? It suggests that they agreed to the purchase and sale of these birds. We have the quantity. It says 4. So we know that, and it's signed by Bo. Assuming Bo is the defendant, which he's always the wrongdoer, let's be honest. But if Bo's the defendant, it just has to be signed by him. Right? So that would satisfy the statute of frauds if we're going through it, right? It indicates that a contract exists, it contains the quantity term, and it's signed by Bo, assuming he was the defendant. Good one, guys. You again, back at the scene of the crime, eh? I need to start locking my office door. Merchant's confirmatory memo would be the other possibility under the UCC, under 2201. So this one, there are a lot of very particular requirements. So it's not like this is going to come up every time. In fact, it only applies when you got to look at the first requirement here, which is it can only occur if both the parties are merchants. And I want to drive home something here. Yes, there are certain provisions of the UCC that require one or both of the parties to be merchants. Just like under the Battle of the Forms under 2207, there are provisions of 2207 that only apply if both of the parties are merchants. And when we have a firm offer rule, the offeror has to be a merchant. And here, when we talk about the merchant's confirmatory memo rule, it only applies if both parties are merchants. However, the UCC itself applies anytime we have a contract for the sale of goods. And so if the question is, are we under the UCC or under the common law? If it's a contract for the sale of goods, we are under the UCC. It is a separate question to say, for instance, does it fall within the statute of frauds? Well, there we say, is the contract for the sale of goods for $500 or more? We're still under the UCC. We're just asking, is it within the statute of frauds under 2201? So don't collapse these requirements. Don't on an essay or a multiple choice question be saying, well, the UCC applies because they're both merchants or because the price of these goods is $500 or more. No, the UCC applies. Why? Because we have a contract for the sale of goods. Are these goods, is there title to these goods being transferred, right? Do they meet the definition of goods? And is title to these goods being transferred to the other party, to the buyer, right? From seller to buyer. Is that what's going on? Then we have a contract for the sale of goods. That is there are particular provisions where we care if one or both of them are merchants, but those are separate. That just goes to the applicability of particular provisions of Article 2. That is separate, and you do not want to collapse all that together. And so here, as we start into this merchant's confirmatory memo, we've got to ask, are both the buyer and the seller here merchants? Is this a contract between merchants? Meaning, these are parties that deal in goods of the kind. They regularly buy and or sell these goods. They have expertise or skill and knowledge about these goods. Then if that's the case, then we're saying, was there a writing sent confirming the transaction? Meaning the parties orally agreed to something. Then one of them sent a confirming memo or letter saying, I am confirming this transaction. You agreed to sell me 4 yaks for $10,000 and you're going to send them to me in 2 weeks. That I'm confirming that. That's what's in view here, that there's a confirming memo or letter sent, a writing. And this is the phrase that trips everybody up when we say, is it sufficient against the sender? What we're asking is this, if the roles were reversed here and we were asking, does this writing satisfy the statute of frauds? Does it satisfy 2201? Then we would look and say, well, if the party that sent it, and the typical scenario would be the plaintiff sends a confirmatory memo to the defendant, right? And they're trying, right? Keep in mind, ordinarily, the default way under the UCC of satisfying the statute of frauds is to have a writing signed by the defendant. Well, now, in the absence of that, there's a possibility, and the only possibility we're going to point at here, to use a writing that is signed by the plaintiff, sent by the plaintiff to the defendant, to use that to satisfy the statute of fraud. So it's contrary to the way we would think about it. It's like, well, how is that fair? Because the plaintiff could just make up a writing. We'll get there. But what we're asking when we get to this step is to say, is that writing that the plaintiff sent, if we were just asking, we're asking, would it satisfy the statute of frauds against the plaintiff? If the plaintiff were the one that was being sued, like if roles were reversed here, would it work? So we're asking what? Was it signed by the plaintiff? Right? Was it signed by the plaintiff? Does it so we're saying, does it indicate that a contract exists? Does it contain the quantity term? And is it signed by the sender, the plaintiff? That's what we're asking with 3. Straight up. That's all we're asking. But then the whole trick here with this way of satisfying the statute of frauds is trying to be able to use this writing against the party that received it. So to do that, these last two requirements are key, right? Because we're asking, does the recipient know the content of the writing? Did they receive it? Do they have knowledge of what's in it? Do they know what's in the writing? Because only if they have notice are we willing to say, we will hold you to this. We're saying, okay, one, did they know what it said? And then two, did they have the opportunity to object and they failed to do it? And remember, the predicate here is these are sophisticated parties. They're merchants. So if one of them is sending a memo to the other, confirming some sort of transaction, then if they're sophisticated, they see it, they know what it says, then if they didn't agree to it, then they better speak up and object. And here it says you have 10 days to give a written objection within 10 days. And if they didn't, the reason it's phrased in the negative is I'm saying when is it that the writing here, the confirmatory memo, satisfies the statute of frauds? It's when they're both merchants. It's when the plaintiff sending a confirmatory writing to the defendant. That writing would work to satisfy the statute of frauds as a writing signed by, quote, the defendant, if the plaintiff who sent it happened to be the defendant. And we're saying, is it sufficient against them? Then we're saying, well, did the other party know it? Do they know what that writing says? They received it. They know what it is, the defendant. And then did the defendant not object within 10 days of receiving it? If they didn't, we view that as you knew what was in there. By not objecting, you acquiesced. You're acknowledging the truth of what it said by not doing that. But we only do that between two sophisticated parties, merchants. Right? So here's an example. Bob's reading this letter from Barb. As we agreed during our phone call today, you will be sending me 200 boxes of chocolate. Very truly, Barb. Whatever. We know where that goes. So Bob got this confirmatory memo, and now she's talking to Herman. I'm telling you, Herman, I haven't heard a peep from Bob in 6 months. I need those chocolates for my chocolate shop. Now, I know you don't want to hear this, but you're out of options. You need to sue him. I know you're right. It's just Bob's such a good friend, but I don't see what else I can do. He's ignoring me. I can't run a chocolate shop without any chocolates to sell. So if we're looking at this, she's the buyer of the chocolates, right? And Bob being the seller. And she is suing him for breach of contract, okay? Suing for breach, that tells us a couple of things, right? As we're stepping through this, right? This means Barb decided she would sue. She's the plaintiff, the buyer of the chocolates. She is the plaintiff. She's suing the defendant, Bob. And Bob asserts as a defense the statute of frauds. He's saying, well, if there was such a contract for that many chocolates at that price, it would fall within the UCC statute of frauds because it's a contract for the sale of goods for $500 or more, and therefore it's a defense. And now Barb has to argue that it's satisfied to get over it, right? To get over this defense that Bob is raising. So here we know what? They're both merchants. She's running a chocolate shop. She's regularly purchasing chocolates. Bob is apparently a manufacturer of chocolates, right? So they're both merchants. Then she sent a writing confirming the transaction. We saw it, right? Bob was reading at the beginning of our little hypo here. And then was the writing sufficient against the sender, right? If we back up here and look, and it says, as we agreed on call, you will be sending me 200 boxes of chocolate. Okay, what do we know? If Barb were the defendant, then it would be signed by Barb, it would have the quantity, and there is language indicating that they came to an agreement, that there was some sort of agreement between the two of them. And, of course, Bob ignores it. Right? So as we're looking through these again, right, we said they're both merchants. She sent this confirming the confirmatory memo or letter, and it's sufficient against Barb. If she happened to be the defendant, then it would work under the category of a writing signed by the defendant, right? Because it would be Bob suing Barb. Barb would be the defendant, and Barb would have signed it. It would have the quantity otherwise be sufficient to indicate the existence of a contract. So yes, it is sufficient against Barb, the sender. And the recipient knows the content of the writing. Yes, we saw him reading it out loud, right? So we know, yes. And he didn't give any objection. Why? Because he threw it in the trash, right? He just ignored it. So all of those things are true, so she can use her letter, assuming she has a copy of it, she can use it to satisfy the statute of frauds against Bob. So let's look at exceptions. Let's say we're under the common law or the UCC and we don't have a sufficient writing. Then what we want to remember, a writing is not the only way to satisfy the statute of frauds, but it is essential that we look to see if it is satisfied that way. If it's not, we can look and say, well, is there, quote, an exception that applies? And depending on what category we're talking about, category of contracts under the statute of frauds, then that is going to dictate what exceptions might be available to us. So there are some exceptions that apply in the common law and there's some that apply under the UCC. When we're looking at the common law, remember the first 5 categories of the common law categories. So, and the exceptions, there are some that apply to all 5 of the common law categories, right? All common law categories. There's some that only apply to the year category, and there's some that only apply to the land category. So we want to think about each of these, right? So if we think about all the common law categories, ones that would apply across the board, we want to think, okay, one of those is if somebody is arguing promissory estoppel, right? They're not arguing for the existence of the agreement. They're saying that a promise was made, there was reliance on that promise. And when you're asking about promissory estoppel in this context, we're not under Section 90, we're under Section 139, and the standard is slightly different. It's a heightened standard and it's a standard that addresses our concerns that are unique to the statute of frauds, right? Because when it talks about how do we know if justice requires the enforcement here, it says, well, we're going to look at things like the definite and substantial character of the forbearance or the action taken in reliance. We're going to look at the reasonableness of the action, the extent to which the action was foreseeable. And all those things, to some extent, obviously are considered under Section 90, but some of that, there's key ones like the extent to which the action or forbearance corroborates evidence of the making in terms of the promise, or the making in terms are otherwise established by clear and convincing evidence. So we're asking, what is it, right? Does this action or the forbearance, the reliance, does it give us a sense of what the terms of this promise were? So those are part of what we're looking at in 139, which are not concerned under Section 90. But if the claim is promissory estoppel, then that would be an exception. If it falls within that, it would be an exception to any of the common law categories. Full performance by both parties. If both parties have already fully performed, and it does not matter that the statute of frauds wasn't complied with, right? Because we are not concerned that the contract was made up because they both already fully performed, right? Well, why did they fully perform? Because presumably they indeed had a contract. So judicial admission, the other thing is if the party admits that they had a contract under oath, so either at a hearing or at a trial or at a deposition, in some sort of a sworn affidavit, something like that, that would be an admission under oath that the contract existed. And if that's the case, again, we're not concerned. If the defendant under oath admitted the existence of the contract, then we are not concerned that there's not a writing because we now believe that it existed because they conceded under oath that it existed. So what about the year category and as common law category? Is if we're talking about, and this is we need to be really careful with this, which is this idea of full performance by one party. We said under the common law, if both parties fully perform, statute of frauds isn't a concern, it's an exception, right? We're not concerned. Well, only in the context of the year category, if one party fully performed, then that too satisfies the statute of frauds, but only in the 1 year category. Because again, it's evident, like we look at it and say, that person wouldn't have done what they did, spent all that money or whatever, because of the fact that we think that evidences that this likely existed. Right? Because one party fully performed, it satisfies the statute of frauds. Then under the land category, the exception, you want to look and say, we need two of the following things. Two of the following things. Usually it's some combination of payment and possession or payment and improvement. So like payment of the purchase price and then the payment of some portion of the purchase price and then possession of the premises or payment of some portion of the purchase price and they've made improvements to the lot or something like that. Those are things that, again, indicate that indeed the transaction was made because they paid money and they're living there, they're in possession, or they paid money and they started making improvements. So, and keep in mind, improvements are not just they hang some pictures on the wall. We're talking about more significant capital improvements. It could be things like they built a shed in the backyard, they put a fence up, those kinds of things would qualify. So what about the UCC? What exceptions are there? So 2201 gives us a number of exceptions, some similar to the common law, some not. So when we talk about them, one of them, again, promissory estoppel would apply straight up. That's not listed in 2201, but it would apply straight up the same way. The other possibility that is listed is judicial admission in 2201. That would work. It would work the same way. Then specially manufactured goods under the UCC. And when you think about specially manufactured goods, you want to be thinking about the buyer placed an order for some sort of specially tailored, specially manufactured goods. And in that case, the way the exception works is if it says this, right? It says under subsection 3 here, under 2201, it says, if the goods are to be specially manufactured for the buyer and are not suitable for sale to others in the ordinary course of the seller's business, and the seller, before notice of repudiation is received and under circumstances which reasonably indicate that the goods are for the buyer, has made either substantial beginning of the manufacturing or commitments for the procurement. So in other words, are these goods, they've started making them, the seller started making them, and now the buyer's saying, no, I didn't do that. I didn't order those gold-plated toilet seats with my initials. Who would do that? Right? Well, I wouldn't have done that. Right? Like, of course, those aren't mine. If the situation is they've started manufacturing, they have the buyer's initials on them, and they are not something that is suitable to for resale, in the seller's ordinary course of business. In other words, is there a market for gold-plated toilet seats with Tracy's initials on them? Probably not. I'm sure there are other people in the world that have the same initials, but it's probably not very big, right? So there's not going to be something that can be resold, right? In the ordinary course of their business. It would take an awful lot of effort. So you would say, if that's the case, then it falls within the exception. Why? Because we would look at this and go, why else would the seller have started doing this if not for the fact that you ordered these? Because they can't resell them. It's not like they can make these and it's like no big deal because they can sell them to whoever. And these have your initials on, right? It's like, this looks like you had a contract. This looks like this was an agreement for you to buy these things. And so that would be an exception. And then the other thing is part performance. Part performance under the UCC, right? We talked about full performance. Remember, under the year category, full performance by one party, it falls within an exception to the statute of frauds. Under the common law generally, we said full performance by both parties. Under the UCC, we're saying part performance. But when we say part performance, what we're saying here is this, that the buyer, right, to the extent, depending on who's the defendant, to the extent that, let's say the buyer is the defendant, and the statute for the buyer, the defendant, the buyer, is raising the statute of frauds. Well, to the extent that they have already paid for some portion of the goods, that they cannot raise the statute of frauds as to that amount that they've already paid for. Why? Because by paying for that portion of the goods, you're conceding that you had a contract for the purchase and sale of that portion of the goods. And vice versa, if the seller were the defendant claiming that, oh, there's we didn't, the statute of frauds applies, to the extent that the seller has already accepted payment for those goods, whatever amount they've accepted, then that would be satisfying it. And then with the buyer, let me emphasize this. With the buyer, you want to think how many of these, to the extent they have accepted delivery of those goods and paid for those goods, or I should back up even further to say, to the extent that they have accepted, I think I phrased it incorrectly, it should be to the extent that they have accepted the goods, right? Accepted delivery of the goods. They cannot raise the statute of frauds. And to the extent that the seller has accepted payment, they would not be able to raise the statute of frauds for that portion of the goods. So those are the exceptions. We need to make sure we keep things straight, which is it can be satisfied with a writing or an exception, okay? And so if it's satisfied, we say the statute of frauds is satisfied. And what does that mean? This is counterintuitive. If you've decided the contract falls within the statute of frauds, within meaning it falls within one of the 6 categories, and either there's a sufficient writing or there's an applicable exception, we say the statute of frauds is satisfied. If it's satisfied, then it is not a defense. It is not a defense if it is satisfied. That is often counterintuitive to students, but that's the way it works. Then the other thing is to say, what if there isn't either one? We fall within one of the categories, right? The contract does, but there's not a sufficient writing and there's no exception that applies. Then we say the statute of frauds is violated. It's violated and it is a defense. It is a defense. So and often that is the opposite of the way that students are thinking, but you want to keep it straight. So that's it. I know it's actually pretty lengthy, but I hope that's helpful when it comes to statute of frauds. There's a lot going on there, a lot of sort of nitpicky rules, but it's doable, right? It's doable. I hope you found it helpful. As always, like and subscribe if you will. I'd appreciate that support. And I will be back with more to come in the coming weeks. So I pray that you're doing well.